Hello, my name is Robert Goodwin, and this is Law on the Line. I would like to welcome back my two guests, Judge Edwin Stern and attorney colleague on the Middlesex County Bar Foundation, Dave Greenfield. Dave and Judge Stern, welcome back, and I appreciate our opportunity to continue our discussion from about a month and a half ago, 2 months ago.
My pleasure. Really happy to be back, and again, congratulations on what I think is a very important public interest program.
Thank you, Judge.
And thank you for having us back.
Okay, so we're going to continue the conversation we had a couple of months ago regarding the New Jersey judicial discipline system, both attorneys and judges who are part of the system, and we have a protocol for their discipline, and it was very topical today, as it was last month, and even more so, perhaps not more so, but relevant, because that's when we were at the station and heard about Supreme Court Justice Thomas and Alito and financial issues involving both of them from donors. So in the state of New Jersey, I want to discuss not only that issue, but just to give our audience a analysis of how judges and attorneys are disciplined. I'm going to start off with you, Judge Stern. Go ahead.
Thank you very much. I've never been disciplined. Seriously, I don't think what is the topic of discussion now among federal judges and the federal judiciary can happen in New Jersey.
And why is that?
Well, because New Jersey's system is well spelled out. Under the New Jersey Constitution, the Supreme Court is responsible for the admission and discipline of attorneys, and so it has created a system for discipline of attorneys. I know you covered that in another program, and we'll discuss it briefly later.
With Dave,
That's correct.
A couple of shows ago. That's
correct. The court also has power over the administration of the courts, which includes discipline of attorneys. And the court has established an elaborate system in terms of code of judicial conduct and discipline for violation of those of the canons of that code. So among judges are prohibited by Constitution and rule from any political activities and from gainful outside pursuit. Their job, and I'm talking now about the Superior Court judges and the Supreme Court justices. I'm not talking about municipal judges.
Who are appointed by the municipal, usually the mayor.
That is correct, or council, depending the form of government.
Right.
In
Correct.
some cases where they're joint municipal courts by the governor.
Oh, that's correct.
Yeah. So, the code indicates to judges what they can do and what they cannot do. There is an advisory committee on outside judicial activities, which can pass upon judges' requests in terms of their ability to speak at functions, attend functions, and the like. They can participate in certain civic activities and charitable work, as long as their name is not associated or used in connection with fundraising. All this is spelled out in the Code of Judicial Conduct.
And where would one find the Code of
It is
Judicial Conduct?
an appendix to the rule book that Dave has in his hand, as an appendix to Rule 118, I believe it is, maybe 114, but it is the Code of Judicial Conduct for judges, and the rules of professional conduct for lawyers are both appendices to the Supreme Court rules.
And referring to rule, as you noted, Rule 114 for
Right.
attorney discipline, 14, and for judges, I believe it's 120-16.
Yeah. Okay. So, as I said, if judges have questions about what they can do or not, There is an advisory committee they can ask about anything concerning their non-judicial activity.
Give us some examples of what would be considered a non-judicial activity that a judge might want to consider and would have to have this passed.
Can I go to a fundraiser where they are raising money for David Greenfield?
Running for mayor?
Oh, then that he couldn't, because that would be a political activity.
Okay,
but the committee could answer that type of question. But if it's storm damage, post-Sandy, some tragedy in his family, can I participate in that? And I think as long as you are not seeking money, and your name is not being used, come lawyers, come to a dinner where we are raising money and Judge Smith is going to be a speaker. In essence, come and be nice to Judge Smith. That can be a real problem because it may give the appearance that somebody's coming to incur favor or the like.
What about a GoFundMe page?
I'm sorry?
A GoFundMe page. Dave is, wants a GoFundMe page, for example. I don't want to put you on the spot, Dave, but...
he sends me those all the time.
But on a GoFundMe page, for example, people are doing that for all kinds of activities, funeral expenses, sadly, or whatever. That's, I think, would judge be barred from participating in something like that?
I think he would not be barred from participating as a contributor or going to a dinner, but he or she certainly couldn't be the subject and certainly couldn't be the one soliciting. Let me give you an example that was a recent case. A judge who wanted to participate in a Black Lives Matter demonstration. In many respects, commendable activity, understandable. But if the activity is going to be critical of the police, then a judge who has to evaluate credibility of police officers and public citizens probably should not participate. You give up certain rights when you become a judge because you have to be neutral, and you have to be neutral in fact as well as perception. So there was there have been cases like that, and there are arguments on both sides, and that's why this committee is organized.
May I interject with a question? Suppose a judge wants to teach as an adjunct in a college, a law course, or a law school.
That's authorized by rule, by code.
Okay.
As long as he or she doesn't get paid. Because you can't have outside judicial pay. You can't have outside lawful, gainful pursuit or outside political activity. Federal judges can, and federal judges do a lot of teaching, both teaching to lawyers and teaching to law students in law schools, and they get paid. New Jersey state judges do not.
So a New Jersey judge, for example, we got the Institute of Continuing Legal Education.
Correct.
Judges participate, offer invaluable expertise. None are paid.
That's correct.
Okay.
No state court judges are paid.
Well, Judge Stern has appeared on many programs in which, in order to be a mediator, you have to take a 4-hour advanced course every year. And Judge Stern has been on many programs if they're to give the course. And as far as I know, he's yet to be paid.
And for the reasons he just stated.
Well, that's why I'm working till 140 years old. Now, but the critical part of the disciplinary process deals with complaints about judges And the New Jersey Supreme Court, and there's a rule on it, it's Rule 120.
120s, yes,
Yeah.
hyphen 16.
Yeah, among others, but it's
Right.
all part of 120.
120, yes.
Citizens who have come to court, feel they've been mistreated, feel that they have been wrongfully treated, can file grievances against judges. Now, and those grievances are accepted, investigated, and disposed of by what is called the Advisory Committee on Judicial Conduct.
And that's set up by court rule.
By court rule, and also, I'm sorry, that's Rule 2:15. 120 is attorney discipline. 2:15, it really doesn't matter, the number. The Advisory Committee on Judicial Conduct investigates and disciplines judges for misconduct, not for judicial error, not for mistakes in decision making. The Advisory Committee on Judicial Conduct and the disciplinary system is not an appellate court. A lot of people come to the committee saying the judge made a mistake, and therefore I don't want to spend X numbers of dollars getting a transcript to make an appeal. Will you correct the decision? The Advisory Committee on Conduct or on misconduct does not have appellate jurisdiction. It doesn't decide cases. It doesn't rule on the merits of a judge's decision. It only entertains complaints about conduct, which conduct can be demeanor, it can be being rude, it can be insulting, it can be any number of things. There have been criticism that the judge was prejudiced against me because my cousin was represented by that judge 20 years ago and therefore knew me, or my adversary's sister plays golf with the judge's wife and therefore favors my adversary. You have that sort of things, which can be investigated. Those types of issues should be raised in a case and decided by the judge. But again, to be repetitive because it's important, people are invited to file grievances against judges who they think the grievant thinks mistreated them, but can't seek an appeal from this committee.
Well, that's an interesting point. I guess people sometimes get confused.
They do.
Who sits on, or how is the advisory committee created?
The advisory committee is pursuant to Rule 2:15, appointed by the Supreme Court. There are 3 retired judges, there are 3 attorneys, and there are 3 public members. Supposedly, or in fact, members of the community that have outstanding reputations and judgments.
How long is the tenure of a member of the committee?
I just finished my 12th year. Most committee members get 4 3-year terms.
Up to 4 3-year terms.
Up to 4 3-year terms.
And appointed by
the Supreme Court of New Jersey.
I see.
And so a complaint comes in, the committee looks at it through its staff. A staff reviews every complaint. Most, to be honest, get dismissed out of hand by the committee. Everything is presented to the committee, but most get dismissed out of hand because they are not within the jurisdiction of the committee. That is to say, it's a complaint about a decision, it's a complaint about the judge not knowing the law, that sort of thing. Many are investigated in terms of the allegations. My brother and the judge are close friends. They play golf, that type of thing. Many lead to questions submitted to the judge himself or herself, or to staff of the committee before going to the judge to gather information about the complaint. And then the committee reviews each matter. As I said, most are dismissed off the top because they're not within the jurisdiction of the committee, and they really are within the jurisdiction of an appellate court. Then the committee can do any number of things. As I said, they can go talk to the investigative staff, can go talk to the complainant, can talk to the judge's staff, can listen to the court reporting. There are a lot of complaints about the judge treated me poorly. He interrupted me. He wouldn't let me speak. He criticized my dress. He criticized the way I spoke. He was rude and abrupt. Those types of things, and I'm sorry for being rude and abrupt and interrupting you.
No.
But those sort of things can be handled somewhat summarily by listening to the tape and interviewing people that were there.
May I interject again? I believe there were reports in the press where judges have exhibited sexual hostility to litigants and to their own staff, which probably wound up before the committee.
Very, very rare, but yes, there have been some, not only on sex, but on all other sorts of groupings.
And that would apply under the purview of the committee, not necessarily a litigant having a grievance against a judge, but just overall general conduct. That would be
precisely, exactly.
And you have a staff that would do and conduct the investigation.
The primary investigator is a retired state trooper. Oh. And then what happens is the committee has the right to dismiss complaints or grievances. They don't reach the complaint stage until the committee finds enough merit to file a complaint.
Sort of like a probable cause.
Exactly, precisely. And with a dismissal, the committee can also write letters of private discipline to the judge. It can be from the least form of discipline, called an admonition, to a reprimand or a censure. And that can be private, and it goes into a file which becomes a part of the permanent record, so that if something like that happens again, next time you're considering the aggregate.
I see.
There are occasions where a judge is called in to an informal conference with the committee to help him or her understand what has been criticized. Many judges, and we're talking about a very few.
That's what I was going to ask you. After 12 years, I mean, what is a very small percentage of judges are ever involved?
I would say 98% of the cases are disposed of without any public discipline. Maybe 95. It's in that area. There is a fair amount of private discipline in the form I said before, in terms of private letters, which go to the assignment judge, the chief judge of the county, and to the chief justice, becomes a part of a record. And much of this relates to new judges. But because the judges are hardworking, they're very good. And people have bad days. You can have 100 people waiting and you want to move a case along, and sometimes the judge may seem a little abrupt to a litigant. Mm-hmm. And there's a complaint, a criticism, a grievance, because the judge wouldn't let me talk. There are reasons sometimes, or a judge is new and despite education for new judges has not had an experience similar before. So after the investigation is done, and as I said, that can include an interview with the judge, either with staff or an informal conference to talk about an issue. There are I would say, and this is an estimate on a per year basis, 12, 14 formal complaints filed a year. because once a complaint is filed, then the matter is public.
That's what I was going to ask you. So, private, then public, and then what are the remedies that the committee has in terms of discipline?
Once the complaint is filed, an answer is filed by the judge, usually through counsel, doesn't have to be. The judge frequently says, I made a mistake, and it can be disposed of with a recommendation even then of discipline. Or in any event, before discipline can be, well, and there can also be discipline by consent. I can come in and say, you know, I made a mistake. I thought about this. I didn't realize this or that. I consent to the findings of fact that I violated a code of conduct, and I can even consent to an admonition or some sort of public discipline, short of removal. The forms of discipline, as I said before, are private, which can be a letter of admonition, a letter of reprimand, or a letter of censure, or public, which can also be an admonition, a censure, an admonition, a reprimand, or a censure, and then there are a few cases where there is a suspension for any amount of time and even removal from office. And if there is a recommendation by the committee to remove a judge from office, then if the Supreme Court that gives it what is called a de novo review, it has the report and recommendation of the committee in a form of a presentment. In other words, after the complaint is filed, there is a hearing. Due process requires a hearing. The judge, as I said, could waive it. The judge can enter into a consent with committee staff as to fact finding, with the committee recommendation of discipline, or as consent as to discipline, or there can be an adversarial hearing.
And this is before the Supreme Court.
This is before the committee.
Before the committee.
Prior to the Supreme Court. So if it's, I know I'm repeating and I'm sorry, if it's by consent or after an adversary hearing with right of examination and cross-examination, the committee files with the Supreme Court what is called a presentment. And it makes its findings of facts and conclusions of law presented to the Supreme Court that reviews it. The Supreme Court has argument, and if the recommendation, which is very rare, but there have been two recently that I recall within the last 2 or 3 years, if the court finds and agrees with the recommendation of removal, then a 3-judge panel is appointed to hear the matter again, prosecuted by the Attorney General, defended by the judge's attorney, and then there's another trial with a greater burden of proof. Before us, it's only clear and convincing evidence. And a removal proceeding, it's beyond a reasonable doubt.
The same standard applied in the criminal case.
That is correct. And all the removals that I recall, and I recall actually 3 recently, are more the result of the judge's case lacking credibility than the actual underlying charge. And that's unacceptable for a judge who has to evaluate credibility to be incredible. And thank God, and I know a lot of judges, and I've been there, it's a very rare exception. I can't state it enough. But I guess when people get behind the 8 ball, things happen.
I'd like to segue over. How does the judge discipline distinguish itself from attorney discipline? Because there seems to be very parallel systems in place.
Well, this is true. Attorney discipline, well, there were ethics committees established in each vicinage, which some may be a single county, maybe several counties. Anybody can file a grievance against an attorney. The an attorney is assigned to investigate the grievance, speaks to the respondent, speaks to the grievant, gathers paperwork, and makes a recommendation. The recommendation may be dismiss, or the recommendation could be there is clear and convincing evidence to go forward with a formal complaint. Once a formal complaint is filed, then we have a...
And that is now public, is that correct?
That is public. Then we have a hearing with presented by an attorney. The two attorneys and a lay member sit on a panel, and the presenter sets forth his or her case. The attorney maybe respond. Sometimes the attorney will admit to the charges, and then there will be a recommendation, again, an admonition, a reprimand, a censure, and usually these involve cases are not of the most serious nature. They could be failure to communicate with your client, lack of diligence, advertising problems, conflict of interest, things that are serious but not.
So there's another layer to this, and I believe we talked about this, if the problems involving an attorney are more serious or more where it perhaps is criminal in nature, and that's a whole separate issue, but as far as being monitored, reprimanded by our peers, there's a professional group of that is embodied in our court rules. What is that, Judge?
Exactly. There is an office in Trenton within the court system called the Office of Attorney Ethics. They, among other things, do random audits of attorney trust accounts. They help educate attorneys.
We have 1 minute.
To professional responsibility. And in a more important case,
significant.
More significant in terms of discipline.
Correct.
A case where an attorney goes into a trust account which holds attorney's money, client's money after settlement of a case, for example, or an escrow account. If the lawyer goes into that account knowingly and uses the client's money or the escrowee's money, that lawyer under New Jersey law is disbarred for knowing misappropriation. Those cases are usually presented by the central staff and heard by one person as opposed to volunteers called the special ethics master. The procedure is the same. After the report and recommendation of the master, it goes to the disciplinary review board that reviews the matter de novo, and it can make a determination. It makes a determination.
The DRB is basically an appellate
DRB
tribunal.
at that point.
DRB is an appellate tribunal.
And certain recommendations are final, and others go to the Supreme Court. The Supreme Court must hear all cases recommending disbarment or on a petition by a party that doesn't like the DRB's decision.
I see. Well,
Did
gentlemen,
I make the minute?
Pardon?
Did I make the minute?
We made the minute. Yes,
Okay.
And
Thank
again,
you.
I know
My pleasure.
Each time we only touch upon a small sliver, it seems, but I think that the public at least has an idea that we're very regulated and I think self-disciplined.
We are, and the Supreme Court makes sure that the perception of justice and that there's a good perception of justice by making sure that those that don't follow the rules are disciplined.
Well, thank you.
Thank you.
Again.